Sure. A very warm welcome to all our members. I take this opportunity to thank everybody who is joining this particular session. I believe mediation being the latest trend in the industry, everybody will be benefited from the session that we are going to start. With us is the Central Council member, C.S. Ashish Karodia ji. Welcome, sir. I'll just pass on the mic to sir and sir will take over. Hello, sir.
Thank you, Riteshji. Good afternoon, everyone. My warm welcome to all of you. Friends, keeping up with the commitment of the ICSI to provide continuous in-depth theoretical and practical knowledge to its members, the institution has taken initiatives in the niche area of ADR through web series of mediation. This webinar series will help the company secretaries prospecting towards relating fields to becoming multidisciplinary professionals with inclusion of the new role as mediation professionals. The second webinar of this series shall focus on orientation uh, of mediation. To address this, we are having with us Ms. Tanu Mehta, ma'am. We welcome you, ma'am. Friends, Ms. Tanu Mehta is a legal professional, mediator, arbitrator, and conflict resolution specialist with over 25 plus years of experience. She is currently also the honorary chairperson of the Committee for Mediation and Conciliation at the Bombay Chamber of Commerce at Mumbai. She started her career in litigation practice. Tanu moved on to ADR over the last 12 years. She has been consulting with various organizations and institutions as an independent mediator and conciliator and handling mediation case referrals from courts. She was also instrumental in launching India's first MA in mediation and conflict resolution while acting as director of the Center for Mediation and Research at the Maharashtra National Law University, MNLU, Mumbai between 2019 to 2022. She is also a visiting faculty for mediation certification at the Praveen Gandhi Law College, Mumbai, and ILSCA Pune. She has been a speaker and a resource person at various judicial conferences in Maharashtra, India, and uh, has presented papers at the Asia Pacific Mediation Forum and the World Mediation Organization. Certification education qualification of her. Friends, she also holds a master degree in conflict resolution and mediation from Tel Aviv University, Israel, 2010 to 11. She has done her LLB 1993 to 1996 from Government Law College, University of Mumbai, and her graduate degree is in sociology, BA from KC College, University of Mumbai. Additionally, she holds the following certificates, mainly are certificate in the Interfaith Dialogues Facilitation by Seeds of Peace, IICA Certification Course of Mediation and Negotiation, Mumbai 2016, Regulatory Requirement for the Members of Institutional Ethics Committee Certificate by CDSA, Pune 2016, Good Clinical Practice by CDSA, Pune 2016, certificate in community industry dispute resolution by Media Culture 2012, certificate in conflict analysis by United States Institution of Peace 2011. So with this, once again, we welcome you, ma'am. And now I may request to ma'am to deliver the session. Ma'am, please.
Thank you. Thank you so much. That is a very, very comprehensive introduction. I wish I had that much information on all of you because I would love to be introduced to all your members and all of you. First of all, congratulations to your organization, ICSI, which is doing such good work and bringing out such interesting lectures throughout for all your members. So that's very, very commendable. Thank you for this. Thank you also for inviting me to deliver this lecture. I'm honored, and it will be such a pleasure to interact with you all at some point of time physically. So we'll start our lecture today. I was hoping it can be interactive, but considering that it is I am told that there are more than 500 people joining. It won't be interactive. So I'm just going to go in a lecture format. But in case you have questions in between, please send me links to the questions and I'll be happy to answer. I'll be happy to pause my PPT and answer your questions accordingly. Is that all right?
Yes, ma'am, please.
All right. Thank you. So, an overview of mediation. What is mediation? For all of us, without going into definitions, I'd like, to give a very, very simple understanding of how all of us understand mediation. It's basically the act of intervention by an informal and neutral third party in an ongoing dispute to resolve a dispute. And it needs to be voluntarily accepted by all parties to a dispute. So as you all know, it has to be an intervention. So there has to be some dispute for any mediation to take place, whether the dispute is in your home or whether the dispute is in your profession or it is between your neighbors. Some dispute, some discomfort going on in a relationship between two parties needs to happen for a mediator to intervene. And two, it needs to be voluntarily accepted by all parties. So unless all the parties to the dispute, whether there are two parties, three parties, if all of them don't accept, you cannot have mediation. So acceptance of the mediator has to be voluntary. It cannot be forced. All right. That is meant to be ideal mediation. Now, what would the qualities of a mediator be? Primarily, if we were to take even today without any formal application, who would you go to as a neutral, as as somebody who could mediate for you? The person has to have the reputation of being neutral, right? There has to be neutrality. There has to be credibility of the person. There has to be a trust for the person. And there has to be an informality to the process. So what really happens is whenever we have a dispute, when we choose a mediator, usually pehle to we would have gone to the elders of our family if there was a family dispute, or the elders of our community if there was a community dispute. And who would we choose? There are many elders, but we don't go to all of them. We generally choose people who are credible, who are neutral, who are considered fair, neutral, and who can be trusted. Trusted with what? With being honest, with being courageous to say the things that need to be said. So there has to be trust by both the parties on the mediator, and it has to be informal. If it is too formal, then we get lost in process. There has to be an informality that we can go and talk about anything, that we can go and not be bothered about, whether we have followed the right process, whether we have followed, the right dress code, whether we have followed all the. No, there has to. That is what we are looking for in a mediator. And that is what, even now, as we are going into, more professional mediation, these are primarily 4 qualities that we are still looking in mediators. So till date, where all has mediation been used in India? It has been used in family and labor disputes. This, that for longest time, we've had, the family law as well as labor law had something called the conciliators. ये बात अलग है कि वो ठीक से नहीं हुआ है, लेकिन at least it was allowed in the provisions. Mediation has been used by communities in their internal disputes. So all of us know that, whether there are khap panchayats or there are, all these community matters. Like I know that the Ismaili Khoja community has its own dispute center, meaning mediation center. The Kachhi Jain community has its own mediators. The Palanpuri Jains have their own mediators. Certain Vaishnav communities have their own mediators. Matlab, internal community mediators have been a part of our lifestyle for the longest time. Then mediation is used by business guilds. I don't know if you all know, there was the cotton exchange at one point of time. There were so many business guilds that always had their own internal conciliation committee or mediation committee or whatever that committee was called, which was meant to resolve disputes. And of course, labor disputes always had a conciliator, which was appointed by the government. But even independently, within the industry, there were enough people who could be gone to for finding resolution. So we've always had the concept of mediation run in India. So I don't know how many of you know, but Companies Act does have a provision. I think it's 442 or something section where they've made provisions for a mediator to be involved. It's another thing that it is not involved as much by parties yet because it is not yet brought in process, but legally it's acceptable. But now, with the new Mediation Act coming in, the Mediation Act of 2023, mediators will be formally recognized. And mediation is a skill that will have, if we want mediation as a profession, then we have to develop skills which will come from proper trainings. But it is also an art that will have to be developed to be made as a proper profession. So remember, it is not easy to simply be certified as a mediator and start mediating. As I said, it's an art where we are wanting neutrality, like I said earlier, credibility, trustworthiness. All that will not come simply by a certification, right? We will have to develop it. And therefore, developing it as an art, as a behavior, will take time, but it is something that we have to develop if we want to take it up as a profession. Any questions till now? All right, I'll go ahead. So what is the difference between then and now? Now meaning now after the Mediation Act or after mediation has become so popular. What is the difference between then and now? See, mediators were there even earlier. All right. पंचायत में क्या होता था? मीडिएशन ही होता था. या हम जब ऑम्बुड्समैन के पास जाते हैं बैंकिंग इंडस्ट्री में, क्या होना चाहिए? मीडिएशन ही होना चाहिए. लेकिन टेक्निक्स एंड स्किल्स नहीं थे. टेक्निक एंड स्किल has to be developed. If I am sitting in the place of an ombudsman, for example, or I am sitting in the place of a commission, okay, and I am going to be authoritative and I am going to say, देखो आपको ये करना है वरना हम ये कर लेंगे, आपको ये करना है वरना हम आपको इस तरह से hold करेंगे. So then I am using authority more than the skill of bringing a party to a resolution. Okay. अब ये recognize कर रहे हैं कि mediation जो करते हैं, चाहे आप कोई भी पोजीशन में बैठ के करो, आप जब मीडिएट करते हो आपको वो स्किल आनी चाहिए कि लोगों को अपने आप इस तरह से आप उनको कॉन्वर्सेशन में लीजिए और इस तरह से आप उनसे बात कीजिए कि वो खुद ही बोले कि नहीं हमें ये इस तरह का सॉल्यूशन चाहिए. सो द स्किल एंड द टेक्निक ऑफ गेटिंग पीपल to come to their solution rather than forcing a solution on them is the skill of mediation. Therefore, proper training modules have been designed now. पहले में और अभी में क्या फर्क है? पहले बिना ट्रेनिंग हम मीडिएशन में चले जाते थे. तो अगर मेरी रेप्यूटेशन है कि भाई ये अच्छा, ये इनके पास चले जाओ, ये अच्छा कर देंगी, तो लोग आ जाते थे. Maybe I had an internal skill, maybe not. Maybe I just had trust of the people. Maybe I was known to be neutral. But people would come because लोगों को लगता है we will mediate. Not anymore. Now, proper training is required. We have to go through long hours of training modules and then come to what we call the mediation mindset, enabling us with the techniques and skills that we have learned during these training modules and then attempt mediation. अच्छा, इन ट्रेनिंग मॉड्यूल्स में क्या गया है? Many hours of psychological and behavioral research करने के बाद ये ट्रेनिंग मॉड्यूल्स बने हैं. तो आप जब ट्रेनिंग लेते हैं, ऐसा ही नहीं है कि कोई भी कुछ भी बोल देता है. बहुत कुछ उसमें गया हुआ है जिसकी वजह से प्रॉपर ट्रेनिंग मॉड्यूल बना है और फिर आपको सिखाया जाता है हाउ टू बी अ मीडिएटर. Because it is now so good, acceptability has increased. The acceptability of bringing in an outside mediator for resolving disputes has now increased across everything. It has increased in the judiciary, it has increased in the legal community, it has increased in communities like yours, of company secretaries, of chartered accountants, of doctors, जो professions hai, engineers, everybody, every community now is recognizing, whether it is a community of professionals, whether it is the community of castes, whether it is a community of people, whatever it is, people are recognizing कि भाई जब बहुत ज्यादा dispute हो रहा है and we are not able to go anywhere, let's get a mediator because हमसे ये अब हो नहीं पाएगा, हमारी बातचीत से बात हल नहीं होगी. And people are recognizing it. And execution of decisions taken after a mediation is done, जो decision लिया जाता है, जो consent terms आए जाते हैं, they have been given now a formal status via the new Mediation Act 2023. So if you are going to bring people to a consent, what happens to those consent terms? What are those consent terms called? How are they to be registered as an agreement? What is the value of that agreement? How will that agreement be executed in case some party fails it? ये सब अब via the new Mediation Act आ चुका है. So big strides have been taken. While mediation is a very very old word, कहते हैं श्री कृष्ण ने mediation किया हुआ था, of course which had failed, but he tried very hard. तो अब in India, in fact, I had gone like I was introduced, I had taken training in Israel, a proper training. In fact, I had done a master's in mediation and conflict resolution. And let me tell you, I was the only Indian girl in that class. And Indian in that class, girl, boy, chodiye, Indian in that class. And I remember my professor, who was an American professor, picking me up and saying, oh, she's come from India. Do you know where the concept of mediation has come from? The first concept of mediation is in the Vedas. This is what he told me. I didn't know at that time. So that is mediation that we have always been as a tradition, as a culture. We have included mediation as a dispute resolution, but now it is coming back to us via trainings from the West. Whatever it is, we have to adopt it and we have to go forward with mediation and take back ownership of our great tradition of mediation. So let's now go to the Mediation Act 2023. I just want to know, any questions till now? Ritesh ji, Ashish ji?
नहीं मैम, हम सारे क्वेश्चंस लास्ट में लेंगे जितने भी आएंगे ना पार्टिसिपेंट्स.
All right, thank you. So now let's go to the Mediation Act of 2023. अभी एक्ट नोटिफाई हो चुका है, पर एक्ट के सारे प्रोविजंस नोटिफाई नहीं हुए हैं. Let me tell you this, because under the act a council will be made, a mediation council, and once the council is made, they will be making the internal rules via which this whole mechanism will come into function. Okay, so we are still waiting for the council to be made, for the rules to be notified, but at least the act has been passed by the parliament. That is a very very big step. It has been notified in the Gazette, again a very big step, and some of its provisions have been notified. So right now we will just understand what is this act. So I'm taking from the preamble. This is an act to promote and facilitate mediation, especially institutional mediation, for resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body of registration of mediators, to encourage community mediation, and to make online mediation as acceptable and cost-effective process and for matters connected therewith or incidental thereto. So let me explain this preamble. This is an act to promote and facilitate mediation. तो जब mediation जो भी कोई कर रहा है या करना चाहता है ये एक्ट उसको प्राइमरीली उसको फैसिलिटेट करने के लिए बनाया है, सो दैट देयर इज अ प्रमोशन ऑफ दैट होल कॉन्सेप्ट। एंड अगर कोई लोग मीडिएशन कर रहे हैं तो उनको एक एक्सेप्टेंस मिले, especially institutional mediation. Here is the most important thing. So for example, ICI do mediation. So if ICSI has its own panel of mediators, okay, mediators who are trained, then ICSI can actually empanel with the mediation council, जो council बनेगा उसके साथ empanel करके कहें कि भाई हम institutional mediation करेंगे and it will be acceptable. And then ICSI can do mediation for its own community disputes, meaning disputes between your company secretary professionals, disputes within industries or where company secretaries are involved. Whatever it is, ICSI can start taking mediation cases and doing mediation. It is for resolution of disputes. Obviously, mediation किस लिए होता है? We want to resolve disputes, commercial or otherwise. So you can take up commercial or other kinds of disputes too. Enforce mediated settlement agreements. Let me go back 1 minute. Commercial or otherwise. So for example, you're saying, all right, commercial dispute hai, dispute between two companies, dispute between two firms regarding, certain provisions, certain acts, certain execution, etc. But it could be non-commercial also. For example, सोसाइटीज में डिस्प्यूट्स होती है, आप सब किसी ना किसी सोसाइटी के मेंबर होंगे, आप कोई ना कोई फ्लैट होल्डर होंगे, कोई सोसाइटी, दूसरी सोसाइटीज होती हैं, ट्रस्ट्स होते हैं, इतने मैटर्स होते हैं जहां कोई ना कोई डिस्प्यूट चलता रहता है. तो वेदर कमर्शियल वेदर नॉन कमर्शियल, whether it is a community, whether it's a society, whether it is any organization, any matter, even family matters, one can start mediating if one is part of an institution which is registered with the mediation council. We can enforce mediated settlement agreements. So jo agreements banenge after mediating a certain problem, they will now be called MSA, mediated settlement agreements, and उनकी बहुत वैल्यू होगी, because जब कंसेंट से आपने कुछ किया हुआ है तो उस अग्रीमेंट को हाईएस्ट वैल्यू होता है, बिकॉज बाय कंसेंट है तो एविडेंस की जरूरत नहीं है, बाकी किसी चीज की जरूरत नहीं, एवरीथिंग हैज कम बाय कंसेंट. सो हाउ विल दैट बी एग्जीक्यूटेड, उसके बारे में इस एक्ट में दिया गया है. एंड देन प्रोवाइड फॉर अ बॉडी for registration of mediators. So even if you're not attached to institution, if you're an independent mediator, you can be registered with that mediation council. It is meant to encourage community mediation, like I just said before, and to make even online mediation as acceptable and cost-effective process. Just like I'm giving you an online lecture, there are many mediation cases that I personally do, which are online. Some party may be in, Jammu and Kashmir, some party may be in Kanyakumari, some party may be in Assam. It doesn't matter. If I'm working as a mediator via an institution, we set up our own mediation room like a Zoom room. Okay. We go ahead with mediation. Both parties come online. We are, it's so comfortable क्योंकि हम Sundays को कर सकते हैं, हम शाम को 8 बजे कर सकते हैं after a whole working day. Whatever it is, it depends on the comfort of the parties and the mediator, and it can be done online, which makes it so cost effective. So that is the scope of the act, that it wants to facilitate easy resolution of issues. Next. So why was there need for this act? We were seeing, and I'll talk to you from my perspective, because I am a mediator empaneled with the High Court, the City Civil Court for the last 12, 15 years. I've been practicing for 26 years, but I came into mediation only later. And then once I had trained, I got empaneled with the High Court, and I've got empaneled with other institutions as well. So why was there a need for this act? Number one, we need acceptance of mediation and promotion of mediation. क्योंकि आज हम as lawyers we can be mediators, but what about you as company secretaries? Don't you want to be mediators? There must be so many amongst you who can become such good mediators, because there is already trust, there is already credibility, you already have a reputation of neutrality. So why should all matters come to courts? Before it goes to a court, even institutions themselves can and should be able to look into matters and see if there can be resolution. So this act came so that there could be a formal recognition of mediators outside the law, right? Because otherwise only lawyers and judges tend to do everything, right? So it is necessary for other people to be trained, especially professionals, because they do a much better job. They understand the technicality of the issue. They understand the practicality of an issue. They understand the ins and outs of everything. और उनको अपने पार्टीज के बारे में भी समझ है कि क्या कहते हैं, क्या करते हैं. So there is a much more easier way to, help resolve disputes without going to a judge or to a lawyer. Therefore, number one, this act was necessary because now it will involve everyone. Another reason why it was necessary was you need to give formality and strength to a mediated settlement agreement. So let's assume you have mediated something and there is an agreement. How do you get that agreement not only registered, but executed? So both parties have agreed. For example, I'm just going to give you a rough example. Two parties have agreed after a mediation that, all right, I am going to do ABC. In return, the other party will do XYZ. I will do this by this time. The other party will do this by this time. After we have both done this, we will take the third step of commonly doing PQR. Okay. तो ये जो आपका अग्रीमेंट बना, ये अग्रीमेंट बनने के बाद एबीसी आपके सामने हो गया, XYZ आपके सामने हो गया, पर ये दोनों का कॉन्सिक्वेंस जो PQR होगा, तब तक तो मीडिएशन नहीं चलेगा. तो आपने वो अग्रीमेंट में डाल दिया है एंड यू ट्रस्ट दैट द पार्टीज विल do that act. But if they don't do, then there is an agreement to go back to, and they can actually get it executed, that this 1/3 last thing was remaining. This needs to be done. Therefore, this needs to be done under this settlement agreement. So, the execution becomes faster via a third authority, whoever that authority is. Primarily, these two reasons, apart from the fact that if we have an act, then every mediator who is registered under the act, under the council, one, he starts becoming what we call professional mediator. And we don't take unprofessional mediators to do a job, because unprofessional mediation, which is basically untrained mediation, can be pretty disastrous. So we want to ensure that जो भी mediation कर रहा है वो अच्छे से train होके करे, because we want a higher success rate. So therefore, the need for this act. Who can be mediators? Anyone, ICSI members, non-ICSI members, any member, anybody, one who's trained to be a mediator. The training now, right now, we say that, certification comes after 40 hours of training, but not necessarily, because certification is one thing. Empanelment is important. So there will be institutions that will empanel you. Like there might be many people holding a certificate of 40 hours, but many lawyers, but are all of them empaneled with the High Court? No. वो तो फिर एक empanelment आपका कमिटी होता है which sees कि apart from certification आप में क्या quality है. It's like saying कि भाई मैं MBA हूँ इसलिए मुझे जॉब मिल जाएगी क्या? नहीं, उसके बाद इंटरव्यू होगा, so that you will get your empanelment. So similarly, there will abhi to, because we are doing it informally, there is a 40-hour training module that is done by different institutions. I'm also a trainer, so I train as a facilitator and a resource person for many institutions. But once the mediation council comes, they will decide कि ये training is valid training. These institutions can give valid training certificates. So a trained mediator after going through that particular training, can apply to the council for becoming empaneled. And there will be an interview criteria and they will be empaneled. But it can be anybody. It can be my mother or your mother, whom we know, she's always neutral. Like, of course, don't forget, Ambani settlement came with their mother's mediation. Apart from 2 or 3 very important people, it was the mother who had the trust and the credibility to intervene in the brother's dispute. But so can it be for thousands of people whom all of us in society know कि भाई ये बहुत अच्छा mediation करते हैं, या इनके पास कितनी credibility है, या इतने लोग इनको trust करते हैं. All of them can come into the formal system of mediation. They can be trained and they can be allowed to be mediators. How will it affect law and litigation? How do you think it will affect? For a lot of lawyers, they think, array, matters come ho jayenge. But I personally think that our system, our legal system is failing because we have a lot of unnecessary matters in the system. A lot of matters which have, jiska base sirf ego hai, या नॉन कम्युनिकेशन है, या कोई मतलब नहीं, बैड डिसीजन मेकिंग है. Many matters like these are clogging and blocking proper court system, because वो इतने ज्यादा भर गए सिस्टम में कि जो real important matters हैं of policy, of law interpretation, of actual dispute regarding a policy, that is not being able to be heard, and unnecessary litigation is being taken. So I feel it is going to affect our system beautifully, and all the matters that are only regarding ego or privileges or things like that, they can be settled in mediation itself, because mediation will help you to recognize that कि भाई इसमें there is just non-communication और कोई प्रॉब्लम ही नहीं है, या इसमें किसी का ईगो हर्ट है इसलिए उसने ब्लॉक करके रखा है, ये थोड़ा सा वहां हम हैंडल कर लें अच्छे से तो ये मैटर आगे बढ़ जाएगा. एंड दोज मैटर्स कहते हैं ना छन जाएंगे, एंड रियल actual matters can remain in litigation where the judge requires to put his mind. So in my view, it is going to affect law and litigation in a very, very positive manner, and good things will come out due to this Mediation Act. I'm going to now read out certain salient sections of the Act, just for your information. Of course, all of you can get the Act online and see and read up everything. These salient features are because I feel, at least non-lawyers need to know how it is so important and how this Act is opening up the whole sector of dispute resolution to every professional. So the mediation service provider shall, while appointing any person from the panel of mediators maintained by it, consider his suitability and the preference of the parties for resolving the dispute. Let us assume ICSI is a mediation service provider, okay, registered with the Mediation Council under the Mediation Act. So that service provider, while appointing any person from the panel, तो जब ये service provider है तो इनके panel होंगे mediators के, ठीक है, ये अपने rules बनाएंगे, इनके panel होंगे mediators के. So while appointing any person from the panel of mediators, consider his or her suitability. ठीक है, तो आपके पास panel है और आपके पास dispute आया है, तो आप सोचोगे भाई इस dispute में it is better that I involve a person because ये person में ये खूबियां हैं और ये person इनके लिए ज्यादा acceptable रहेगा because उसको ये भी समझ है वो भी समझ है जो भी, ठीक है. And of course, while appointing, the preference of the parties for resolving the dispute is a must. So if the parties to the dispute look at your panel and say, भाई ये आपका 20 या 1000 ये 100 लोगों का पैनल है, इस 100 में से मुझे ये नंबर 49 वाला चाहिए क्योंकि ये पर्सन हम दोनों को लगता है सुटेबल है, तो आप 49 नंबर वाले को दीजिए. तो बेसिकली इट्स बोथ. Resolution will happen, one, by the preference of the parties for the mediator, and of course by your own policy and your own understanding of who will suit where. You may also have a rotational policy, whatever, but mediation service provider shall have the freedom to appoint that person. If you have any questions, please keep putting it on the chat and I will answer in the end. Another salient feature is that every mediation under this Act shall be undertaken within the territorial jurisdiction of the court or tribunal of competent jurisdiction to decide the subject matter of dispute, provided that on the mutual consent of parties, mediation can be conducted at any place outside the territorial jurisdiction. So, for example, there is there are two companies fighting over something. There is a dispute over something, and unke contract mein likha hai that any arbitration or mediation shall be within the the jurisdiction shall be in India. तो आप mediation India में कर सकते हैं, ठीक है? या अगर उन्होंने लिखा है any such dispute will be set, any dispute under this contract will be held or will be done under the jurisdiction of laws of Maharashtra. Okay? आप उधर करवा सकते हैं उनके laws के अंडर, तो jurisdiction वो रहा, लेकिन अगर दोनों parties का mutual consent है, then that mediation can be held even outside of Maharashtra. It need not be only in Maharashtra. It can be under the jurisdiction of Maharashtra, but it can be outside. So if both parties, let us say there are two charity, I recently got to know that there are plenty of charitable institutions that are registered in Uttarakhand because वहाँ का law कुछ better है. But there are institutions, that are functional in Maharashtra, the charitable institutions. So suppose there are two charitable institutions that say we will be decided, our disputes will be decided as per the law of Uttarakhand, but they are both in Maharashtra. The mediation can happen in Maharashtra. The mediation can also happen online. I mean, you could be sitting in Maharashtra, the mediator could be sitting in London, as long as we know that the jurisdiction of the mediation is of Uttarakhand. So again, it's giving a very, very wide, scope to enter into mediation anywhere, as long as we know that this is the jurisdiction as per the contract or as per the law. For the purposes of record, mediated settlement agreement, this is section 20. Mediated settlement agreement arrived at between the parties other than those arrived in a court or tribunal referred mediation or award of Lok Adalat or final award of the permanent Lok Adalat. So they are saying other from tribunal referred mediation or court referred mediation. So basically an agreement arrived in by institutions like ICSCI, okay, may at the option of parties be registered with an authority constituted under the said act. तो हर वो जो act अब council बनेगा उसमें एक authority लिखी जाएगी जहां आप वो register कर सकते हैं, or any other body as may be notified by the central government in such manner as may be specified, and such authority or body shall issue a unique registration number. So all your mediated settlement agreements will have a unique registration number. And provided that the MSA under this section may be registered with such authority or body situated within the territorial jurisdiction of the court or tribunal of competent jurisdiction. So वो तो जो contract में लिखा होगा वही आपका jurisdiction होगा, but it can be registered with a unique registration number so that आपके लिए बाद में execution becomes easy. Section 20 continues. The registration referred to in subsection 1 may be made by the parties or the mediation service provider. See, again, they are keeping it open. दोनों parties जाके register कर सकते हैं या mediation service provider register कर सकता है within a period of 180 days from the date of the receipt of authenticated copy, provided that this may be allowed to be registered after expiry of 180 days. on payment of fee. तो again कितना आपको time दिया जा रहा है कि भाई अपना agreement register करा लीजिए for future purposes. Section 27 enforcement, as I was talking earlier, कि enforcement अब होने लगेगा. So a mediated settlement agreement resulting from a mediation signed by the parties and authenticated by the mediator shall be final and binding on the parties and persons claiming under them respectively and enforced. Subsection 2. What is subsection 2? Subject to the provisions of section 28, the MSA shall be enforced of the CPC 1908. अब of course CPC change हो जाएगा because नया law आ रहा है. In the same manner as if it were passed by a court and may accordingly be relied on by any of the parties. So it almost becomes like a decree of the court, okay, or a judgment of a court, and you can straight away, whatever the procedure says, you can straight away go to court for it. If at all, you have to go to court. The central government, this is section 31, shall by notification establish for the purposes of this act a council to be known as the Mediation Council of India. I was just talking about it earlier. This has to be still done. And mediation service provider, like I was saying, suppose ICSI registers itself. So who is a mediation service provider? A body or an organization that provides for the conduct of mediation under this act and the rules and regulations made thereunder and is recognized by the council, or an authority constituted under the Legal Services Authorities Act, or any other body as may be notified by the central government, provided that the bodies referred to in clauses B, C, D shall be deemed to be MSP recognized by the council, the mediation service provider recognized by council, as may be specified. So you all can apply once the council comes in to become a service provider, provided of course you make your proper rules and regulations which are in alignment. You have a proper trained panel of mediators which is in alignment with what the Mediation Act says. Any institution can actually go forward and become a mediation service provider. Section 43, any dispute that is likely to affect peace, harmony, and tranquility amongst the residents or families may be settled through community mediation with prior mutual consent of the parties. For the purposes of this section, the application will have to be made before legal services or district magistrate or subdivisional magistrate where no such authority has been constituted. So I am looking at a future place where if we have disputes like the kinds we had in the Ayodhya case, like the kinds that we had in other cases, community cases, jahan community mein disputes ho raha hai, ab koi zaruri nahi hai sirf court. Agar koi bhi institution hai which is acceptable to both parties and it says ki chalo hum mediate karte hain, you can apply and you can start the mediation. Because kai baar aisa hota hai that parties are ready for being mediated by somebody they trust, by institutions they trust, by people they trust, and if they are members of a certain community, they may prefer कि भाई ये दो मिलके अगर हम कर लें mediation तो it's okay. So you never know what is going to happen, but we are hoping that we are going to give a wide trained mediating community to our society to choose from for resolving their matters. Now it's time for your questions and for your discussion. Thank you. And I hope this was, educative enough for you, interesting enough for you. I'm very happy to take questions now.
Madam, I'm a Dr. Rajesh Agarwal.
Yes.
There's some question come from the participant.
Yeah.
The question is that society or partnership can impart in mediation.
Sorry?
So
Can?
society or partnership can impart in mediation.
Society, yeah, if you're a mediation service provider registered with the council, yes, so you will have to build that way, build आपका own panel, show your rules and regulations and get empaneled. with the mediation service provider, with the mediation council.
Another question, madam. Can member of ICSI become a mediator, or any special education qualification is to be acquired?
So yes, ICSI members can become mediators, but to become a mediator, you need to be qualified, meaning you will have to undergo the training of mediation.
Okay, thank you, madam. One more question is the last question. That is it necessary to register the mediation settlement agreement even though it is executed within 180 days?
देखिए, it is on the choice of the parties. अगर वो execute हो ही चुका और आपको लगता है नहीं करना है तो मत कीजिए, बट आप अगर जानकार लोगों से पूछेंगे जिन्होंने मीडिएशन किया है तो आई लेट यू नो दैट कई बार एग्रीमेंट एग्जीक्यूट होने के बाद भी कभी ना कभी फ्यूचर में कुछ प्रॉब्लम हो जाती है. ओके, कोई ना कोई छोटी सी प्रॉब्लम, ठीक है, तो एग्जीक्यूट हो गया, लेट अस से मनी आ गया, लेट्स से देयर वाज अ प्रॉब्लम वेयर बोथ पार्टीज हैव अग्रीड दैट भाई हम इतने से इतने पोर्शन में इतना मनी लेके वी आर रिजॉल्विंग द इश्यू. ओके, मनीज आर पेड, it's gone into the parties' accounts, matter is closed. After 2 years, okay, some tax person comes and says कि अरे ये जो मनी पे किया इसमें हमको भी एक इतना टैक्स आना चाहिए था, तो अब टैक्स आपको देना है. उस समय सपोज वन ऑफ द पार्टी सेज आई एम नॉट गोइंग टू गिव टैक्स, या मैं नहीं मानता हूं ये, अदर पार्टी सेज नहीं हम क्यों दें टैक्स, हमारा नहीं है. उस समय जब भी आप वो टैक्स प्रोफेशनल के पास जाओगे, ओके, व्हाट विल यू टेक विथ यू? एन अग्रीमेंट कि भाई इस अग्रीमेंट के अंडर हमने ये टैक्स दिया था. सपोज द टैक्स प्रोफेशनल सेज यू शुड नॉट हैव पेड दिस मच, ये गलत है, एक्चुअली आपका सेटल एक्चुअली इतना पेएबल था, आप लोग ने इतने में कैसे सेटल किया? देन आपके पास एक अग्रीड एक सेटलमेंट है जो रजिस्टर्ड है. सो व्हेन यू टेक इट टू दैट टैक्स अथॉरिटी, he will have to agree because it's it is a registered agreement, so he can't enforce his own law. So हम जानते हैं as experience कि better to settle, but of course there will be parties who will say क्यों settle, मतलब क्यों agreement register करना है, छोड़ो.
Okay, thank you.
वो आपके ऊपर है.
Can I take on more question, madam? 3 more questions.
Take आराम से. I would love for all interaction.
The next question is that who are providing the training in mediation, where one can impel?
देखिए, बहुत इंस्टीट्यूशंस प्रोवाइड कर रहे हैं एज ऑफ नाउ. आई हैव माई सेल्फ डन ट्रेनिंग्स इन लॉ कॉलेजेस कीप डूइंग ट्रेनिंग. देयर आर अदर ऑर्गेनाइजेशंस लाइक आर बॉम्बे चेंबर ऑफ कॉमर्स. हम लोग
we are also providing the training, madam.
या तो आईसीएसआई ट्रेनिंग प्रोवाइड करता है, हमारा बॉम्बे चेंबर ऑफ कॉमर्स करता है, आई थिंक फिक्की भी करता है, कंपनी आईसीएआई करता है. कितने लोग ट्रेनिंग करते हैं, तो आपको कहीं ना कहीं बस जाके ट्रेनिंग लेनी है.
The another question, madam, is the mediation agreement if not enforced in time, what is the remedy for it?
That's what. So if it is not enforced, it is your order. Let's say an agreement is not enforced, it's an order. तो दैट ऑर्डर का एग्जीक्यूशन के लिए यू कैन डू व्हाट इज नेसेसरी. जब हमारे पास एक ऑर्डर या अवार्ड होता है, हम कहाँ जाते हैं? अंडर सीपीसी. वो सब स्टेप्स आप डायरेक्टली ले सकते हैं. यू डोंट नीड टू गो बैक टू द कोर्ट, यू कैन स्ट्रेट अवे गो टू द एग्जीक्यूटिंग अथॉरिटी, राइट? जैसे हम लोग अब डिक्री होता है तो आप कहाँ जाते हैं? आपके पास ऑर्डर होता है, आप कहाँ जाते हैं? यू कैन गो स्ट्रेट टू द शेरिफ. अगर किसी का लैंड लेना है, डोंट यू गो टू द शेरिफ्स ऑफिस, डोंट यू गो टू द पुलिस, डोंट यू गो टू द बेलिफ. स्ट्रेट अवे यू कैन डू दैट.
Okay, thank you, madam. One more question is that what is the training method of mediation for the ICC member?
Training method for all mediation is same. You have to undergo the training of whatever that 40, 50, 60 hours by an institution that is recognized and become a mediator.
This is the last question, madam. Now, madam, it is my privilege to have been asked to propose vote of thanks on this occasion. I, on the behalf of President ICSI, extend a very hearty vote of thanks for the gracing this occasion and sharing your valued knowledge with us, ma'am. Madam, we are all inspired by your valuable insight on mediation. Thank you very much, ma'am.
Thank you. Thank you for inviting me. It has been a pleasure to meet you and to do, to have this interaction with you all.
Thank you, madam. Thank you.
Best of luck, and may you soon become a mediation service provider as soon as the mediation council is set up.
Okay, thank you very much, madam.
Thank you.
Hello. Yeah, please.